Hello, friends. This is paper number 3, Introduction to Law and Governance. My name is Derek Moma, and I'll be taking you through this topic of Introduction to Law and Governance. Now, to set us off, we have some objectives. And some of these objectives are to equip the learner with knowledge and attitudes that are going to enable the learner to apply principles of laws and legal systems in an entity to ensure compliance with basic principles of governance and ethics. So basically, if you're working in some entity, you need to have an understanding of the principles of law, the general ones, and how the legal system works. Once you understand those, then you will have a better competence. So we have learning outcomes. So at the end of this, what do we want? Number one, a candidate is supposed to be able to demonstrate a knowledge of the essential elements of the legal system. We shall be discussing these essential elements. How do you approach the court? How do you get a remedy? In what instances are you supposed to approach a court? You need to demonstrate a knowledge of legal personality. Legal personality is like the law of the estate of a deceased. The estate of a deceased is a legal personality. A company is a legal personality. A partnership is a legal personality. So we need to understand some of these legal personalities. We need to also be able to apply the law of tort and contract in various scenarios. We shall have an understanding of what tort and contract are. We also need to know how to apply the general principles of business law in practice. We also need to be able to apply the principles of ethics in practice. And now, for today, we need to discuss the sources of law in Kenya. And what is a source of law? Sources of law have been described differently by different scholars. In the words of Salmon, a source of law is one from which the law derives its validity. So a source of law is what makes the laws become valid. So if, for example, if someone tells you to do something today, you will ask who said so and since when. So the sources of law are the ones who said so. So according to Salmon, a source of law is the will of the state is manifested in statutes or decisions in court. So Salmon narrows down his definition of a form of source of law as those that are in the statutes and the decisions of courts. G. Williams says that when we talk about sources of law, we're concentrating on two factors, the legal and historical sources of law. So the law has legal sources and historical sources. So to begin with, a legal source is legislation and precedent. So basically, legislation and precedent is referring to the laws that have been passed by the National Assembly or the Senate, depending on what the Constitution says, what entity the Constitution says can pass legislation. So if the National Assembly has passed a law, an act of parliament, then it becomes legislation. So according to G. Williams, he says the legal sources is legislation and precedent. And precedent refers to those decisions that court has made, which are used later on to make other decisions in other courts or within the same court. And according to G. Williams, historical sources are the actual sources of the rule, which is adapted by the court in arriving at its decision. And a very good example of this is common law. We have borrowed, in Kenya, we have borrowed our common law from England. And so England is our historical source of law. So the above are manifest in section 3. So both of the above are manifest in section 3 of the Judicature Act, which is Cap H, Laws of Kenya. So section 3 of the Judicature Act sets out the sources of law in Kenya, and they're in the following order. So they rank from the highest to the lowest. So the supreme source of law in Kenya is the Constitution. So the Constitution is an instrument, is the one instrument of law that a majority of us have gone to a referendum and have passed it as a law. There is no other law that any of us may have participated in passing. So the Constitution is the one law that most of us have had a hand directly in deciding the contents. So the Constitution applies, and all other written laws also apply. So other written laws are subject to what the Constitution provides for. So where the Constitution is silent on some conduct or some procedure, then we go down to the Acts of Parliament. So Acts of Parliament of Kenya, you can always find them on the Kenya Law website. That is www.kenyalaw.org. So those are Acts of Parliament. We also have Acts of the UK, which are cited in part 1 of the schedule to the Judicature Act. We are going to look at this and we'll see which ones apply and which ones do not. And also as modified by part 2 of the schedule. So next we have the substance of common law. So according to this hierarchy, where the Constitution is silent and all written laws are silent, is when we go down now to the substance of common law as one source, to the doctrines of equity and statutes of general application that were in force in Kenya on 12th of August, 1987. So these are relevant only to the extent that the Constitution and written law are silent. So common law can never ever override the substance of what the Constitution provides or all other written laws. We shall be discussing the substance of common law in subsequent proceedings. African customary law is also a source of law, and African customary law is applied in the High Court and subordinate court. Yes, that is section 3.2 of the Judicature Act. And these apply in civil cases where one of the parties is African. So we apply the African, you are able to apply the African customary law to the extent that it is permitted. And you'll realize that this African customary law cannot apply if it is repugnant to morality and repugnant to justice or is unreasonable. Because some of our African customary laws have become repugnant due to the passing of some laws like the Anti-Female Genital Mutilation Act. We also have Islamic law as a source of law, and Islamic law is mostly applied in the Qadhi's Court under the Qadhi's Court Act. And Islamic law is, we shall be discussing it in detail, and it only binds parties who are both of Islamic faith. Now, let us look at the Constitution as our first source of law. So the Constitution was enacted on 7th of April, 2010. That is when it became in force in Kenya. So it sets out the framework for social, political, and economic problems. So it tells us where we have a social problem, what are we going to do about it? Where we have a political problem, what are we going to do about it? Someone has been elected, has been declared as the winner of a presidential election, but someone else is contesting it. So what are we going to do about it? We need to do something and we need to move on. So, and also the economic problems of our society. Now, according to Hans Kelsen, he says that the Constitution is a basic norm. And what he says is that all laws flow from one basic norm. So that if you're talking about the Kenyan context, you can always say that all laws are flowing from the Constitution as the basic norm. He argues that the basic norm informs all the other laws. And I tend to agree with him because it is from the Constitution that we have constitutional acts of parliament and all other written laws that we have, all other sources of law always flow from the Constitution. So a constitution is the supreme law of land in Kenya. We don't have any bigger law in Kenya apart from the Constitution. So Kenya has a written constitution, while on the other hand, Britain has an unwritten constitution. We shall be looking at this in the classification of constitutions. Now, constitutionalism is a principle of constitutional law. And basically what constitutionalism is that it's a system of governance where power of government is limited by the rule of law. What does this mean? That government and the government actors, each time that they see the Constitution, they need to feel bound by it. They need to feel the force of the Constitution, even when there are no orders forcing them to comply with the Constitution. So when you're taking an action and you feel like you are not going to take that action simply because the Constitution says you cannot do it, then now it means you are practicing constitutionalism. It is like the spirit of the Constitution. You are living within the Constitution and you understand what it says. It means something to you. You practice it like a faith. The way people practice their faith and refrain from doing acts because the faith that they believe in tells them not to do those acts. So if you follow the Constitution, the same way you follow your faith, then you are basically practicing constitutionalism. So it is a system of governance where power of government is limited by the rule of law. You feel like as long as the Constitution says this, we are not going to do it. That is the practice of constitutionalism. Article 2.3 of the Constitution brings about another aspect of the Constitution. And this aspect is that the Constitution is not subject to challenge before any court or tribunal. So it brings out supremacy of the Constitution. So by saying the Constitution is supreme means that you cannot challenge it and you have to follow it. It guides everyone else, every other item of law, every other court, it binds everyone. So therefore it is a supreme law. So Article 2.3 reserves supremacy to the Constitution. So what is a constitution in the wording of Aristotle? And Aristotle says, it's the way of life of a citizen or a body. So he doesn't even talk about the Constitution. He doesn't even talk about the Constitution as a law. What he says is that the Constitution is a way of life. You live through the Constitution and the Constitution lives through you. It is your way of life. You practice it. So a Constitution determines the structure of governance of a country and the country's political field. So there is a Constitution might decide that you have a parliamentary system of governance, or a Constitution might decide that you have a presidential system of government. So where the Constitution provides that you have a presidential system of governance, that is the system you're going to follow. People go to an election, elect a president, the president becomes the head of state and also becomes the head of government. So that forms a presidential system of government. On the other hand, a parliamentary system would provide for a prime minister who is the party leader of the party that wins the largest number of seats in parliament. So that the one who has a majority in parliament is the same person who leads the business of government in parliament. So which are the arms of government? So the Constitution provides for arms of government, one of which is the judiciary. And judiciary is the body that deals with dispute resolution. It also deals with formation of government. So when you're forming government, the Constitution tells you that at this point, the president or the president-elect, upon being sworn in, has a number of time between which to form a government, appoint his cabinet secretaries, in the past they were referred to as ministers. And now, if were it not for the Constitution, then there would be no other way to determine who is going to form government. It also defines the method of removal of public officers. So if a public officer has been in trouble with the law, and the law says that at this point, this person is supposed to be removed. So the Constitution provides for that. It makes provision for removal of a president from office, of a deputy president from office, for recall of members of parliament, removal of the chief justice, removal of any judge of the superior court. So it provides for methods of removing a public officer so that there is no chaos at some point when it is intended that a public officer be removed from office. It also may provide for devolved or centralized government. So this is where you talk about things like a unitary versus a decentralized government. So our Constitution provides for devolution. So it tells us that we need to decentralize power so that we have a government in the national government and also a county government. So since the Constitution provides for that, it is the basis upon which we have counties today. We have divided powers between the government at the national level and the government at the county level. Were it not for the Constitution, we wouldn't be having that. So the Constitution of Kenya 2010, and the Constitution has a preamble. And in the preamble is the first port of call when you start reading the Constitution. So the preamble states the beliefs that we have. It also states the aspirations we have as a nation. And therefore, every interpretation of the Constitution is supposed to take into account the preamble of the Constitution. So the Constitution is divided into chapters, and it has 18 chapters. So what are the contents of these chapters? So chapter 1 provides for sovereignty of the Constitution and supremacy of the Constitution. So it says that the Constitution is supreme and is not subject to challenge before any court. Chapter 2 is the Republic. Chapter 3 is citizenship. How do you acquire citizenship? How can you lose citizenship? It prescribes for that an act of parliament should be provided to determine citizenship in Kenya. And it itself says who becomes a citizen and who does not qualify to become a citizen. Chapter 4, the Bill of Rights. And the Bill of Rights, all interpretations are supposed to go to the High Court. Land and Environment, Chapter 5. So in this Constitution, we have a whole chapter discussing the issues of land and environment. It also gives methods in which we should use the land and environment sustainably, some principles. Chapter 6, leadership and integrity. Who are you electing to office? Are you having leaders elected or appointed coming into office with questionable characters? So chapter 6 tends to attempt to give us what we should regard when choosing leaders, choosing by way of election or by way of appointment, that leaders must be leaders of integrity. Even appointment to the judiciary requires integrity. Public Service Commission requires integrity. Chapter 7 is a leadership representation of the people, and representation we are told that all power belongs to the people, but they shall exercise it through their elected representatives. So you can exercise it directly or indirectly through your elected representatives. So we are represented at the National Assembly, we are represented at the County Assembly, we are represented by our governors, we are represented by the president. So representation of the people is a whole chapter in the Constitution. We also have the legislature. So the legislature now narrows down the issue of representation and goes down to the legislature, the body that makes our laws. So it can make laws directly or indirectly. We shall see what this entails. It also provides for the executive, and the executive is the body of government that comprises of the president and his cabinet. And we shall be looking at what the composition of the executive entails. Chapter 10, the judiciary. We shall be looking at the regime, the current regime of the judiciary that provides for a Supreme Court, that provides for specialized courts, at Article 162, specialized courts. So that is the Environment and Land Court, and also the Employment and Labor Relations Court. We shall also be looking at the judiciary. We shall also be looking at how you can appoint a chief justice or a judge, so to say. We shall also be looking at how they are removed from office if the issue so arises. We shall also be looking at chapter 11, discusses devolved government. So it provides for the 47 counties that we have. Chapter 12, public finance. We have chapter 13 on public service, chapter 14 on national security, chapter 15 on commissions and independent offices, chapter 16, amendment of the Constitution. We shall be coming to this, amendment of the Constitution. It's a very vital aspect of constitutional law. Chapter 17, general provisions. Then lastly, chapter 18, which are the transitional and consequential provisions. Now, the Constitution has other contents. So these other contents are that it is divided into 264 articles. So when you're quoting the Constitution, you will refer to Article 1, Article 2, Article 10, Article 159. And so that is how you cite the Constitution, as opposed to our old Constitution used to be cited through sections, but the current one is cited through articles. So whenever citing the Constitution, kindly state Article 10, Article 15, Article 159, Article 260, so forth and so forth. So you use articles, and this is a conventionally accepted practice. It is accepted in court, it is accepted by academicians, it is accepted everywhere. It also has 6 schedules. So the first lists the counties that we have, all the 47 counties. The second refers to the national symbols, the national flag, and the national anthem. All these are there. The third schedule discusses national oaths and affirmations. So the oaths that are taken by the president, the deputy president, CSS, cabinet secretaries, principal secretaries, senators, members of the National Assembly, speakers of both houses, the chief justice. So it provides for the oath. It gives the wording of the oaths. Then the fourth schedule, which shows the distribution of functions between national governments and county governments. So it will say this certain function belongs to the county government. For example, agriculture. The government does not come in. It is a devolved function. So the fifth schedule refers to legislation that should be enacted by Parliament. And the sixth is a transitional and consequential provisions. Now, classification, what you need to know is that constitutions are classified into different classes and on different bases. Not all constitutions are the same. Constitutions don't resemble each other. They are not of the same type. So let us see some of the examples of constitutions and the classes they fall under. Now, the constitutions can be classified on the following basis. So the basis on which you can classify a constitution as follows. One is on the basis of whether it is written or unwritten. So we have written constitutions and we also have unwritten constitutions. So the next one is on the basis of the system of government that it provides. So a constitution can provide for a unitary government, can provide for a devolved government, it can provide for a parliamentary system of government. And the third is on the basis of whether it leads to a unitary or federal government. We shall be looking at this. And also on the basis of the ease of amendment. Shall be looking at constitutions and we shall be seeing which one is easy to amend and which one is not. Now, we need to first look at classification of constitutions on the basis of whether they are written or unwritten. So a written constitution is one where the fundamental principles of administration of the state are embodied in a single document. If you see this document, it is a single document which provides for the fundamental principles of administration of the state. They're in one document. So it is easy for us to conclude that Kenya has a written constitution and we shall not be faulted. We have it. It contains all the fundamental principles of administration of the state, all in the same document. On the other hand, an unwritten constitution is one that has several pieces of legislation, practices, political customs, judicial customs, as what they define as the constitution. So just because they do not have one document that they refer to as a constitution does not mean that they do not have a constitution. So if you look at the UK, they have several pieces of legislation, practices, and customs, which they believe to them as being even stronger than what a written constitution would have. They do not have a single document that they refer to as a constitution, but their practices are so unique to them and are so sacred to them that they do not even imagine that they can go against such practices. So that is what basically an unwritten constitution comprises of. It doesn't mean that an unwritten constitution is a constitution that does not exist. So a constitution also cannot be fully written or fully unwritten. You can't have all your laws, all the laws of a country, you can't have them in a book like this one. So the distinction is one of an extent as opposed to form. What do I mean by this? That where the constitution of a country is largely written, where the fundamental principles are in one document, we're going to say it is a written constitution. But where they are spread in several documents, we're going to say it is unwritten. Not because the written constitution contains all the laws that the country follows, but because the fundamental principles are in one document. An example of a written constitution, the Kenyan constitution is a written constitution. The United States Constitution is a written constitution. We shall be looking at the United States Constitution when you're looking at the ease of amendment. An example of an unwritten constitution, we have already said this, the UK Constitution. So in the UK, Parliament passes most of the laws. and it enjoys all freedom to do so. So in the UK, the parliament passes almost everything that they regard to be law, and they have all the unfettered power. And the Queen will rarely refuse to assent to laws to being enforced. We have another classification on the basis of whether it provides for a federal government or a unitary government. A federal government is more clear when you look at the US Constitution. It provides for a clear division of power between the central government and the individual states. So in the USA, they have all these states, and all of them are largely seemingly independent of each other. They have their own, each state has its own police, its own administration. We have Canada, which also has different police, different administrations. So a unitary, this normally provide for a federal state. So in a unitary state, all state power is concentrated at the central government. So in Kenya, what we have is more of a quasi-federal unit, because it has one executive at the center, which has a presence even in the counties. That is why you have a county administrators and who are appointed by the president. So, but all power, all of them, they respond to the president. All of them report to the president. So it is more of a quasi-federal. So even if we have counties, most of the time you'll find police in your county are still Kenya police. They are not police of your county. So it doesn't provide for states, but it provides for counties. The other classification is on the basis of the ease of amendment. This is where you will find constitutions, some that are rigid and some that are flexible. So which one is a rigid constitution and which one is a flexible constitution? So it goes to the mode of amendment. That is how you know a rigid constitution from a flexible constitution. So a rigid constitution is very difficult to amend. It requires so many procedures to make it amendable. It also has very stringent procedures that it becomes an onerous task for you to attempt to amend this constitution. So where it becomes so difficult to amend the constitution, then you're going to say this constitution is rigid. And by rigid doesn't mean that it completely cannot be amended. It just means it is harder to amend. Now, in the United States, the Constitution, in order to have an amendment, you need a 2/3 majority, a supermajority in both houses of parliament. So in the bicameral parliament, in both the National Assembly and the Senate, you need to have a vote from 3/4 of the legislature of all states. And now what has happened is that only 10 amendments have been done since the year 1813. So you can see how difficult it is to amend that constitution. A flexible constitution, on the other hand, it has fewer procedures for amendment. So it is easier, much easier to amend a flexible constitution. So in the UK, the members of parliament have unfettered power to amend the constitution. So they can decide what it is they want as an amendment, and it will take effect. So if the UK parliament decided that all men are supposed to be women, then according to the law, all men are going to become women. So they have all this unfettered power. That is just an example, but it means they have unfettered power to make amendments. Also, we have a Republican versus a monarchical system. So in a Republican system is that you have a democratically elected leader at the national level. So this democratically elected leader, it becomes the symbol of statehood in that country and is answerable to the people. So that is a Republican nation. On the other hand, we have a monarchical system where they have a dynasty, and this one normally runs in the families. So in such a system, what happens is that they have a monarch who remains in power throughout, and power runs through the family. That is another classification of the Constitution. Now, we have been talking about ease of amendment of the Constitution, and here we are. How do we amend the Constitution of Kenya 2010? So we're looking at this, we'll expect you to look at the 2010 Constitution and tell me whether it is rigid or flexible, or conclude whether it is rigid or whether it is flexible. Now, the relevant provisions when attempting to amend the Constitution are articles number 255, 256, and 257 of the Constitution. So these provisions provide that you can either amend the Constitution by popular initiative or by parliamentary initiative. In what instances can you amend by popular initiative, and when can you amend by parliamentary initiative? So under Article 255, when making a constitutional amendment, they need a referendum if you are amending the following provisions. So provisions relating to supremacy of the Constitution, that one you have to go to a referendum. You have to amend by popular initiative. The territory of Kenya, that one is another protected clause. You cannot go through parliament to amend reference to the territory of Kenya. Sovereignty of the people, that one you have to go to a referendum. National values and principles of governance and Article 10.2. Here today, all those principles, you have to go to a referendum. The Bill of Rights, Chapter 4, you have to go through a referendum. You cannot alter the Bill of Rights without having gone to a referendum. The term of office of a president, that one also you have to go to a referendum. You cannot decide that the president has not grown old enough to retire and decide, well, let's just go to parliament and amend this. You have to go back to the people. Independence of the judiciary and the independent commissions and independent offices under Chapter 15. This you have to go to the people. Function of parliament, you have to go back to the people, and objects, principles, and the structure of government. Also, if you are attempting to amend the Constitution, then you also need to go back to the people. So any amendment that is not covered there is supposed to be enacted either by parliament or the people. So now you have discretion over clauses that do not touch on these protected clauses that we have been talking about. So these protected clauses are the ones that cannot be subjected to a parliamentary initiative. Now, where your amendment does not touch on the above, then you have now the discretion. You can choose. Are you going through parliament or are you going through the people? So when you're trying to pass a law by way of a referendum that is through the people, what threshold should you get? What do you need to satisfy in order to say you have amended it successfully? So first you need to comply with Article 257. Article 257 is the one referring to amendment by popular initiative. We shall be looking at this, Article 257. We also need to get a 28% majority vote by the people who voted in at least half of the constituencies. And also you need to be supported by a simple majority of the citizens voting. So you need a simple majority first. Then you need to have a 28% vote in at least half of the counties, not constituencies. So let us look at amendment by parliamentary initiative. The provision there is Article 256. So if you want to amend by parliamentary initiative, you need to introduce a bill in either house of parliament. That is either the National Assembly or the Senate. So you bring a bill, you table a bill before the house. Then the bill cannot be called for second reading in either house unless at least 90 days have passed since the first reading. So the first reading is introduction of a bill to parliament. It is more or less of a formality. So from the date that it goes to parliament, they ensure, the law is there to, Article 256 is there to ensure that you do not call it for the second reading unless 90 days have passed since the first reading of the bill. So what this is trying to curb is that you shouldn't be trying to amend the constitution in a hurry. In the second and third readings, it must be passed by at least 2/3 of the members of the House. We shall be seeing in later proceedings, we shall be seeing what the second and third readings entail and what their significance is. That it has to be passed by at least 2/3. So that is a supermajority of all members of the House. Then you need to publicize the bill and facilitate public discussion on the same. This is public participation. It has to take place. It needs to be published. It needs to be gazetted. People need to discuss it and see whether it fits our scenario, whether it is a good amendment, and inform Parliament that we have looked at these amendments and this is what we think. We think this is a bad amendment for this reason. And Parliament is not forced by the law to follow the recommendations that are given by the public. What it needs to do is that it needs to take them into account. It doesn't have to follow them, but it needs to take them into account. And it needs to demonstrate that it took the public discussion results to account. Then they need to pass the bill, obviously. Having passed the bill, what do they do with it? The speakers of both houses will submit it to the president jointly so that he is going to assent the bill, and they need to present it together with a certificate showing that the bill has been passed in accordance with Article 256, amendments by parliamentary initiative. So the president needs to assent to the bill and make it to be published within 30 days after enactment by Parliament. And the need for publication is so that people are aware that this law has become a law and taken effect in the country. Still on amendment of the 2010 Constitution, we now need to look at amendment by popular initiative. This is amendment by the people. So you need to propose an amendment by popular initiative. We have been told by court in recent past that the president has no power to pass an amendment by popular initiative. So the president does not form part of who the citizens or the Wanjikus are for purposes of passing an amendment, of proposing an amendment by popular initiative. So you need first to do a proposal to amend by popular initiative. The proposal can be either by a general suggestion or by a draft bill. So where it's by general suggestion, the promoter needs to reduce it into a draft bill. So you can also bring it by a draft bill. So you have two options. You can bring it by a general suggestion. You can also bring it by a draft bill. Now, it needs to be signed by at least 1 million registered voters. So you need to circulate it through the country, get it signed by at least 1 million registered voters. And the idea behind this is that it needs to look like it is not, you don't sit in your bedroom and decide, well, I'm passing an amendment, I'm proposing an amendment. You don't sit in your bedroom and say, well, I have decided I'm proposing an amendment. So you need to have it signed. You need to put in some effort, show that it is a serious process. Have it signed by at least 1 million registered voters. So this bill, the promoters are going to deliver the draft and at least the 1 million signatures to the IEBC for verification of the signatures. So the IEBC, its role would be first to take the bill, look at the people who have signed against the bill and confirm whether they are registered voters. They don't need to compare signatures. They're not handwriting experts. So they need to just look at it and confirm that the people who have said they have signed to the bill, so that the million people, they need to make sure that this million are registered voters. That is all that they need to do. And they need to publish the list so that people are able to comment on it. If it is said that you had signed the bill while you think you hadn't signed, then you need to protest and say, this signature does not belong to me. Still on amendment by popular initiative. So the moment IEBC is satisfied that the bill meets the requirements of Article 257, it is going to submit it to each county assembly for consideration. So this is supposed to be done within 3 months from the date when you submitted the bill to the IEBC. So it needs to send them to each county assembly for consideration. So what are the county assemblies going to do with it? Now, the county assembly may approve the draft bill, then the speaker will present it jointly to the speakers of both houses, that is the National Assembly and the Senate, with a certificate that it has been approved within 3 months of having being handed the bill. So they have 3 months to present this bill, to discuss and pass this bill if they're passing it, and present it jointly to the speakers of both houses. So once the bill gains a majority approval, so it has been voted and passed by a majority of the county assemblies, 50% plus 1 of the counties, it is going to be introduced to Parliament without delay. And what is Parliament going to do with it? Parliament will discuss it and needs to pass it. It needs a majority of members of each house in order to pass it. So the National Assembly and the Senate, having received the bills from a majority of the counties, are going to discuss it and consider whether they're going to pass it. If they pass it by a majority of the houses of Parliament, of each of the houses of Parliament, then it is going forth. So having passed it, they're going to submit it to the president for assent. So having presented it to the president for assent, it becomes a bill that can be passed into law. So the provision here is Article 256. You can read Subarticles 4 and Subarticle 5. If either house fails to pass the bill, then it shall be presented to the people for a referendum. So if they fail to pass it, it will go to the people for a referendum. Now, if it relates to matters under Article 255, we had talked about these ones. These are the protected clauses. Then it shall be presented to the people in a referendum. So at a referendum is where people are going to vote for it, and then it is going to become a law. Now, this is a question I'm posing to you. Do we have a referendum law? And can a referendum be held without a law that prescribes the referendum, the manner in which the referendum can be held? End of the class. Thank you for listening to me. My name is Derek Moma. I'm happy to meet you in the next class.